Welcome to week 5. In this week, chapters 8 and 9, we'll be dealing with the management of public health information and the security and privacy concerns that they entail, as well as the governmental regulation of commercial speech in the name of public health and the implications under the First Amendment. The management of public health information generally involves surveillance and reporting. Public health surveillance is defined as the systematic, continuous collection, analysis, and interpretation of data, closely integrated with timely and coherent dissemination and assessment to those who have a right to know so that action may be taken. In the public health field, the sorts of information that public health officials are monitoring are that information which bears on communicable disease. Obviously, COVID-19 is at the forefront of our thinking today, but in the past, measles, syphilis, Ebola, you name it. Also, information is monitored on non-infectious diseases such as cancers and injuries, preventable harms. And also, public health indicators are monitored, behavioral risk factors and things of that like. This information is used together with vital statistics for the purpose of identifying public health risks and designing interventions which will be most effective. The tools that are used for surveillance are various. Basically, the first tool is the gathering and monitoring of available information. This is done in the field of studying the use of alcohol and tobacco. Most recently, maybe teenage use of e-cigarettes or vaping. Surveys were also done. You may have gotten calls at home or received mailings, which are basically surveys where information is gathered by phone, by mail, or by internet. Data registries for cancers and birth defects are created, and they're based on screening and hospital discharge notes. Workers' compensation claims themselves, the paperwork involved in those involves the gathering of information, which is then all contributed to this database. 911 calls, emergency room visits, and sales records of over-the-counter drugs all contribute to this mountain of information which public health officials can avail themselves of in designing public health responses and identifying risks. There are certain rules which govern surveillance. The public health officials and the governmental entities do not have exactly a free hand when it comes to gathering information because there are concerns about privacy and there are concerns about disclosure, and so those have to be observed, and we'll talk about that in a few minutes. But surveillance rules basically come down to dictating what sort of information is reportable. The CDC has recently published a list of 100 reportable conditions. You can look those up yourselves. Surveillance rules also talk about who must report. Doctors, nurses, labs, pharmacies, schools, employers, law enforcement officials are required to make certain reports. The timing of reports is important because surveillance has to be active. The information has to be reported in real time. Otherwise, we lose the effectiveness of the surveillance. The surveillance becomes stale, if you will. And then finally, who gets these reports? Obviously, privacy concerns require that the information not be made available to everyone, but there are certain agencies which must get the information. So public health agencies get the information. Um, and in some cases, consumer safety organizations or environmental agencies and educational organizations may get information which is gathered in the process of surveillance. When we talk about surveillance and the dissemination of the information gathered through surveillance, we have to talk about privacy. As I mentioned at the beginning of the class, as we introduced the subject matter of the class to you, we talked about how the class really comes down to the study of the effort to balance individual liberties against the communal interest of maintaining public health. And this is also true when we talk about the management of public health information, because as you know, we have we have certain privacy rights which may be impacted when public health information is reported. So the struggle to find the balance point is present here when we talk about the management of information. Generally speaking, there's no legal issue when the collection of information is lawful and the names and identifiers are not used. For instance, a pharmacy might report to a public health official how many units of an antacid are sold in a given period of time because they're not identifying the individuals who purchased them or even the reasons why they're being purchased. When we say identifiers, by the way, we're not just talking about names and addresses. It is possible to give other descriptors which so narrow down the possibility of who the individual is that you are really revealing their identity without giving away their names. Um, if you were the only if you were the only redhead who lived on Baker Street in Maplewood, New Jersey, then you would be given away if a pharmacy, for instance, were to say, I sold 16 bottles of antacid in the month of May to a redheaded male individual who lives on Baker Street. My name hasn't been given. My hair, by the way, is not red, but by giving certain descriptors which narrow down the possibilities, you could be revealing someone's identity. So the legal issue is, and it really arises where names or other identifiers are revealed. Now, why does it come up? It comes up because the government wants access to this information. Public health officials have interest in gathering this information. Yet other individuals seek to maintain privacy. Um, Charles Sheen went through a personal health crisis, and his name got out there. Third parties have a right to know about exposures in a sense that they want to know what's going on in their community and whether or not they have things that measures that they should take to protect themselves. But the right to reveal this information to third parties must be very carefully considered in view of privacy rights. Well, it's important to maintain privacy, but a governmental interest is actually served by respecting individual privacy. And why do we say that? It might seem like a contradiction. On the one hand, you would think the government wants private information so that they can act on it, and you would think that individuals want the information not disclosed because they want to maintain their privacy. However, I'm going to tell you that the government likes to respect individual privacy because if privacy is not preserved in the public health or a general medical process, then respondents will find ways to avoid screening and testing and partner identification and notification, and will avoid treatment. Many people with a condition that they might find stigmatizing, if they knew their information were going to get out there and be widely disseminated, might avoid seeking treatment or evaluation. Those at risk for HIV might avoid testing. Opioid addicts might not seek prescriptions for naloxone, for instance. Patient consent to disclosure is not required for disclosure to public health officials because the law provides that that information should and must be provided to public health officials. And actually, public health reporting is an exception to the doctor's general duty to maintain the confidentiality of his patients and the health conditions that they report. So even though public health agencies are required to acquire identifiable data and use it in their capacity as public health agencies, this is subject to limitations. The individuals have some right to control the disclosure and use of the information. The recipients of that information, even when authorized by law, have an obligation to maintain confidentiality beyond that point. And of course, the data, once stored, must be secured. So this really points to cybersecurity concerns. Hacking into a public health database could result in the revelation of tons of confidential information, which by law should be maintained confidentially. Now, where do these privacy rights come from? We may have mentioned earlier that the Constitution, which you all have a copy of, does not mention privacy, but our Supreme Court has recognized consistently now that there is a constitutional privacy right. This goes back to over 100 years. Jacobson in Massachusetts was really arguing in the Supreme Court that he had a decisional and bodily privacy right under the 14th Amendment. So again, constitutional privacy rights are derived from the 14th Amendment. The 14th Amendment, though, does not support a broad privacy expectation. There are limitations on this liberty, as there are with all the other liberties we have studied. In your text, there's a discussion of a case called Whalen versus Roe from 1977, U.S. Supreme Court. And this was the court really grappling with a New York law which required the reporting of all CDS prescriptions. And the law was challenged on decisional privacy grounds under the 14th Amendment. The Supreme Court rejected the challenge, holding that as long as the government has a legitimate interest in the disclosure of the information and takes a reasonable measure to secure the information once it's gathered, then the 14th Amendment is not violated. Beyond the Constitution and really stemming from the authority of the Constitution, there are various state and federal privacy laws which come into play. The federal privacy laws really come down to a couple of things, but we have the Privacy Act, which dictates when public health information can be disclosed with and without consent. We have the Freedom of Information Act, which applies to all kinds of information, not just medical information, but the Freedom of Information Act contains certain exceptions to the requirement to disclose personal and medical files. if the disclosure would be an unwarranted invasion of privacy. The Freedom of Information Act basically gives the ordinary citizen an avenue to make a request of and obtain from the government information which the government maintains in its files. However, when that information relates to confidential health information, then the Freedom of Information Act would say that that information should not be disclosed. We also have the Public Health and Service Act, which protects the information gathered specifically by the Centers for Disease Control. And then finally, we have the biggest one, the one that we're all familiar with, that we call HIPAA, the Health Insurance Portability and Accountability Act of 1996. And here Congress established a national standard, which is what we'll call the rule. This is a floor, a minimum requirement of health information privacy standards. The Supremacy Clause, the one which says that when state laws and federal laws come into conflict, the federal law will govern. The Supremacy Clause says that that the HIPAA Act, which is a federal law, will preempt state laws which provide less protection. So that if we had a state law which did not protect as well the confidential health information gathered by public health officials, but the HIPAA law provided greater protection, the greater protections of HIPAA would apply. HIPAA applies to all information, health-related information, regardless of its content. And the entities which are covered by HIPAA have to seek authorization from a patient to disclose public health information, except when hospitals and insurance companies are in their billing function, that is, seeking reimbursement or payment, or disclosure to public health authorities, and other exceptions which are listed on page 263 of your text. Disclosure, when it is authorized, has to be strictly limited to only the amount which is necessary. When you visit a doctor, you will fill out forms which are related to HIPAA, which is basically authorizing the use of some of the information which the doctor is gathering in the process of the examination or the consultation. The privacy rule on public health really comes down to a conflict between the providers and the public health agencies on how much to disclose. When an agency provides an activity such as the distribution of flu vaccines, they have to separate their functions. So the gathering of information and the provision of medical care are really two distinct functions. State laws and local laws on privacy should be noted. However, there are many local variations, which leads to some confusion. And in an effort to straighten this out and make sure that health practitioners and public health agencies knew exactly what the law was requiring of them, in 1999, the Model State Public Health Privacy Act was passed at the behest of the Centers for Disease Controls. And the idea here was to create a law which would apply across the country and which would be used as a model for parallel state laws on privacy, so that from state to state we wouldn't find much difference. As we know, the liberties that are guaranteed by the Constitution, if unlimited, come into conflict with and sometimes hamper public health efforts. And this is also true of privacy rights. privacy laws can impair public health efforts because if privacy rights were unlimited, then public health information would not get to public health agencies. And if it did, public health agencies would not be able to act effectively on it. Doctors would not be allowed to send information germane to public health concerns to public health agencies. So you could see that the surveillance function of public health agencies would be really hampered if this were true. Fortunately, the way the courts have developed the law in this field, they're trying to seek a balance so that privacy is respected and yet public health efforts are supported. Mental health records and records of gun violence are the sorts of pieces of information which could be used together. Someone with a mental health record who applies for a gun license perhaps should be denied that gun license, or the license should be delayed until further evaluation could take place. There's an interesting case in your text called Tarasoff versus the Regents of the University of California. Here, someone who ultimately committed a violent crime with a gun in therapy told his therapist that he intended to kill his girlfriend. The therapist, not quite knowing what to do with the information and being ultra respectful of his of the patient's privacy rights, failed to tell either the girlfriend or her family, but the therapist did tell the police. The police acted on the information, arrested the patient, but then released the patient with a warning to stay away from the girlfriend. 2 or 3 months later, the patient followed through on his promise and killed his girlfriend. The parents of the victim then sued the therapist, and the court ruled that he, the doctor, had a duty to warn. Now, he did tell the police, which makes this case troubling in a way, and the police sort of dropped the ball. But the takeaway from this case is that, at least in this California case, and at least in California, the therapist may also have had a duty to warn the intended victim, the girlfriend, or the girlfriend's family. In the state of Washington, a case versus Volk versus Demolier, there was a threat, but no specific target. So again, we had, ultimately we had a bad actor who was in therapy expressing a threat, but not really specifying a target. Ultimately, the girlfriend was killed by the patient. The doctor was held to have a duty to inform all foreseeable targets, or at least that this was a jury question. So when this case went to trial, the jury could consider whether the doctor had fulfilled his duty to inform all foreseeable targets. How does the doctor in this circumstance figure out who the foreseeable target is? Does the doctor have to undertake some kind of an investigation, or is it sufficient to tell law enforcement? Well, the legislatures of various states in the nation reacted to these cases because the healthcare providers, in this case the mental health care providers, were stuck. They were confused by these rulings. They were not sure what the law was expecting of them. So many states passed laws giving the healthcare workers the right to disclose, but not the duty. So the right to disclose then would absolve the healthcare worker from responsibility for invading the privacy of its patients under the various state and federal privacy laws. In the state of New Jersey, a healthcare worker is required to warn, but this duty to warn is discharged or satisfied when they notify the police. Here's a link here to some research on national surveys on what different states require of their healthcare professionals in terms of the duty to warn. It's important to distinguish when you consider these questions the difference between practicing healthcare and research, because the standard for disclosure and use differ depending on whether or not you're doing research or you're actually treating a patient. Okay, now we're moving on to Chapter 9, which is all about the regulation of communications by governmental agencies and public health agencies. Um, this is really an interesting issue because it implicates the First Amendment, which is uh, the amendment in the Constitution which guarantees us freedom of expression. And as we'll see later, a lot of times we say, we talk about free speech, but speech is not just the words that come out of our mouths when we speak or what we write, but there's also something called commercial speech, which is the ability of companies and commercial entities to advertise their products in writing on the media. And we'll talk about that in a minute because that's really a battleground between public health and the liberty of expression under the First Amendment. Well, regulating communications is, of course, important to the health of the community because when government and public health agencies of the government regulate communications, they can promote healthy behavior, they can discourage unhealthy behavior, and they can police false or misleading advertisements, which may entice members of the public to engage in risky behaviors and unhealthy behaviors. So, public health education campaigns are a positive use of the tool of communication to support public health initiatives. So, educationally, we've seen campaigns on TV, in the print media, and on the internet on issues as diverse as diet and tobacco, vaccination, drinking and driving, texting and driving, and teen pregnancy, and any other number of things. The government and public health agencies of government will use the power of the media to get their messaging across. And we'll see how this works in some specific cases. The government sometimes uses its power to require the disclosure of public health information. Now, sometimes we talk about the First Amendment in terms of a provision in the Constitution which guarantees that we have the right to speak. But the First Amendment also guarantees our right not to speak or not to say things that we don't want to say. This is just a generality, but let's see how it applies in the public health field. The government will require, in many cases, warnings and labels on products, foods, medicines, consumer products of all sorts. More recently, the government has required dietary facts to be included in menus in restaurants, at least for the larger restaurants, the ones which have national presence, the chains, the franchises that we're familiar with. Warnings and advisories, as we talked about last week, sometimes are voluntary, but sometimes they stem from tort litigation. A bad result in a tort case for a company might convince it to start including a certain label warning of a known hazard. But in the public health field, the agencies like the Consumer Product Safety Commission will require labels and warnings and will investigate safe products. Um, some of the toys and devices that we use in our everyday lives can cause maiming, disfiguring injuries. So things like water slides and hoverboards and certain kinds of batteries have been regulated or labeled as a result. When we talk about food and drugs, the Food and Drug Administration, FDA, is in charge of that. They regulate food, drugs, and cosmetics, and those products are usually plastered with extensive warnings, uh, both prescription and non-prescription drugs. If you can remember the last time you picked up a prescription, if you looked at the information that was included in the bag from the pharmacy, if you set aside a couple of hours, you might get through half of it. Some examples are aspartame, also the sugar substitutes, Splenda, um, saccharin, things like that have had labels for years. Supplements containing iron have warnings on them, and caffeinated products have warnings on them. Mountain Dew um, has been known to include large amounts of caffeine, and there's a case mentioned in your textbook about someone who had a latte, followed that up with a large Mountain Dew and a 16-ounce energy drink, all within 2 hours, and killed himself in the process. Just a total overload on the cardiovascular system, and that's the end of that. The Federal Trade Commission, of course, regulates tobacco and alcohol, um, and is in charge of menu labeling in chain restaurants. Remember, though, that when we talk about the restaurants which have to do this, 75% of all restaurants are too small and fall below the threshold and are not covered by the FTC standards. States get involved in trying to regulate menus too, but in many cases, the state efforts to regulate menus will be preempted. Remember, supremacy clause, the federal law, when it comes into conflict with a state law, will prevail. So it's debatable in any case whether menu labeling has the desired effect. Do people really tailor their choices in restaurants on the basis of what they see by way of menu labeling? And perhaps some people do, but I think for a lot of people, they turn a blind eye and they order the Big Mac or whatever it is that they have traditionally enjoyed in that restaurant. But it's pretty well settled as a matter of law that the government has a right to communicate with the public on matters concerning public health. So, what's the big deal with commercial communications and what's it got to do with the First Amendment? The government has gotten into the business of controlling commercial communications, and uh, yet their ability to control those communications is not unlimited. The limit is very clearly the First Amendment. Uh, so the government can, to some degree, limit and control and prohibit uh, certain advertisements and promotions and marketing of goods and services, but there are limits to what they can do. Um, Commercial speech is protected under the First Amendment. You have to start with that understanding. But certain kinds of speech are never going to be protected by the First Amendment. When we're not talking about public health, Justice Oliver Wendell Holmes once said, by way of an example, the First Amendment is not unlimited in the sense that it would not be protected speech to shout fire in a crowded movie theater and cause a general panic. That would be the sort of speech that would not be protected by the First Amendment. Kind of a silly example. But in the public health field, Speech which is not protected by the First Amendment is that speech which promotes illegal products or services, or commercial speech which is either false or misleading. An example of the first might be someone decides to take out a billboard and advertise that they are manufacturing crystal meth, and a phone number where you could call and obtain the illegal drug. Obviously, that would not be protected under the First Amendment because the product itself or the service is illegal. But sometimes in advertisement, as we know, um, the advertiser will make a claim which is somewhat questionable. This car is the best car. This particular I don't know, computer is the best computer in the world. This is puffery. This is someone making the argument that you should take their product over the other product because their product is superior. It's kind of a matter of opinion, and that's okay. But when speech strays into something which is false and misleading, then it's no longer protected. So, examples. The government could probably ban the sale of high caffeine beverages to kids because it's generally harmful, but they could not bar advertising of high caffeine products generally because the products are themselves lawful, legal. Now, there's the concept of neutrality, content neutrality as it relates to commercial speech for lawful products and services. Um, the government can limit the times when certain ads are shown. For instance, you shouldn't be able to perhaps have beer commercials during that after school period when kids are watching cartoons. As you know, there are no tobacco commercials on TV anymore. And some states have regulated the placement of billboards for certain products like alcohol, saying that they shouldn't be within a certain distance from a school property. But the limitations have to be legitimate and they have to serve a legitimate governmental purpose. And there have to be alternative outlets for the ads because, in the end, if you have a lawful product or service, you are going to be allowed to advertise it. It's just that the government can dictate to some degree, if they have a legitimate interest, when you're going to show it, where you're going to show it. So, what's this got to do with the First Amendment? Well, as we said, advertisement is commercial speech and it's protected by the First Amendment. This is the starting point for any discussion about this. So, when the government acts to regulate commercial speech, it's doing one of two things. It's either limiting truthful speech, which is the advertisement of lawful products, and the courts do not like this. So the government, from the public health standpoint, might look at a product like alcohol and say, yes, I know it's lawful, but we don't like it. And therefore, we want to limit it, or we want to restrict it, or maybe we even want to ban it. And they're not going to get away with that because the product is lawful and therefore it's still protected by the First Amendment. Or the government might require warnings or counter information, which is forcing the advertiser to communicate content they otherwise on their own would not have communicated. Let's use examples. In 1969, it was finally widely known that cigarette smoking was hazardous to your health. Over the years, the warnings on tobacco products have become more and more detailed and more graphic. But back then, all it said was the Surgeon General has determined that cigarette smoking may be hazardous to your health. Well, the tobacco companies, left to their own devices, would never have labeled their products with this warning, but the government made them do it. Another example in the alcohol field, if you pass a billboard which advertises alcohol, you will see a label on it which says that according to the Surgeon General, women should not drink alcohol during pregnancy because of the risk of birth defects, and that the consumption of alcoholic beverages impairs your ability to drive a car or operate machinery and may cause health problems. Tobacco, I've got a link there. There's tons of information on tobacco. I would advise you to explore it on your own. And now the new one, and one of my pet peeves, as I have teenage sons, is e-cigarettes or vaping. FDA now and state and local governments are struggling with how to try to regulate this. This product was initially put on the market to help people perhaps quit smoking, yet it's a nicotine product that's highly addictive. And the manufacturers of these devices have developed marketing strategies and variations on the product in terms of what it looks like and how it works, and flavors. There are some 15,000 flavor varieties available on the market. Many of them are mimicking flavors of candies that would be attractive to kids and not necessarily a mature adult. So the feeling is generally that the vaping companies are targeting young consumers, and because the product is so um, strongly addictive, they may end up developing an entire generation of nicotine addicted um, um, customers. So, a warning which the product now contains says simply that the product contains nicotine, and nicotine is an addictive chemical. So what? I'm not sure that's effective enough. So we'll see what happens there. But the medicine on vaping, although there have been some initial reports, is not fully developed. I have posted this week an article on TED-MD by a physician who gives quite a good talk, 15 or 16 minutes long, on what we should know as parents about vaping. And I would encourage you to take a look at that. It's very revealing. So the First Amendment protects the right to speak, but it also includes the right not to speak. And when we get to the constitutional limitations on the government's power to regulate speech, commercial speech, a certain test has developed, and this test comes out of a case called Central Hudson Gas and Electric Corp versus Public Service Commission of New York from 1980. The test announced by the court there has four parts. And unless the regulation of the government meets all four of these parts, satisfies all four of these tests, then the regulation will fail as unconstitutional. The first part of the test requires us to ask the question as to whether the speech uh, concerns lawful activity and products and whether or not it's false or misleading. If the answer to either part of that question is no, that is, if the um, product is either unlawful or if the advertisement is false or misleading, then the case is over, and the First Amendment doesn't apply to protect that kind of speech. Second part of the test is whether the government's interest is substantial. What do they hope to accomplish? Well, generally speaking, in the public health field, the government's interest is almost always substantial. So when they're talking about tobacco or alcohol, or hopefully in the near future, vaping, I think that the courts, I predict, will hold that the government's interest is substantial enough to sustain a regulation. The third part of the test is whether or not the law directly advances that governmental interest. So the government might have a compelling interest, but if the regulation is off the mark, in other words, it's not really uh, properly aimed to addressing the government's legitimate concern, then the law will fail again. And then finally, this is the hardest part of the test, is the restriction more extensive than necessary to accomplish the goal? Whenever the government acts in the public health field, whatever measure they take always has to be narrowly tailored to address the problem, but to cause no impact on liberties or health, but liberties beyond what is strictly necessary. So, uh, looking at this test a little bit more, if we had the advertiser of crystal meth with a billboard that said crystal meth's great for your brain, it'll help you get a higher score on your SAT, this is demonstrably false, and this sort of an ad would not be protected under the First Amendment. Or one which says that cigarette smoking improves lung function, obviously false, no protection. Anything that's manipulative or subliminal makes the case a little bit more close because, as you know, some advertisements don't come right out and make crazy claims like this, but they are manipulative. I don't know if any of you are old enough to remember, perhaps, but when advertisements for tobacco products, cigarettes were prominent, there was a character named Joe Camel, and I'll talk a little bit about that in a minute. The substantial governmental interest, the protection of children or the public health is almost always upheld. The restriction has to be efficacious, has to be effective, and no more restrictive than necessary. And this is hard for the government to prove in some cases. Okay, so let's talk about the example of tobacco advertising and governmental efforts in that field, since this is probably the most obvious one and the most heavily litigated one. um, Cigarette smoking in this country and around the world was pretty much ubiquitous up until a certain point. It was even claimed at some points that smoking was good for your health. Ads featuring doctors would promote the use of tobacco products in this way. In 1969, that all changed. Evidence started to emerge that lung disease was resulting, and other health problems too, was resulting from the use of tobacco products. And the first Surgeon General's warning was required to be placed on cigarettes. Uh, Tobacco is a leading cause of preventable death. Um, in 2009, the federal government passed the Family Smoking Prevention and Tobacco Control Act, which authorized states and cities to limit the time, place, and manner, but not the content of ads, which sort of got around the preemption argument. And then in 1996, we had the Tobacco Settlement Agreement, which 46 states signed on to. But basically, the federal government, the state governments in unison sued the tobacco companies, and they sued them on the basis of representing their people. Public health was the reason for the lawsuits. The tremendous burden placed on the public health system by the various diseases caused by smoking, and also the revelation that the tobacco companies for years were sitting on top of mountains of research and clinical studies, which proved beyond any doubt the link between tobacco smoking and serious health issues, and including lung disease and death. As a result of the settlement in 1996, limits on advertisement were negotiated between the governments of the various states and the federal government. and the tobacco companies. In addition to that, hundreds of billions of dollars were paid by the tobacco companies and are still being paid on a payout plan, which I think extends through 2025. Billboard ads were restricted. Joe Camel, I'll talk about that in a minute. And sporting event sponsorships of tobacco products were prohibited under the Tobacco Control Act of uh, ultimately 2009. But here we'll take a look at the two typical ads. The one on the right is the Marlboro Man. This guy generally riding a horse on a range, tough guy, rugged individual. This was the face of the tobacco advertising effort for many, many, many years. More recently, we had the Joe Camel example, and this is what I mean by subliminal. What does the advertisement tell the viewer of the advertisement? You can see clearly that Joe Camel has cool sunglasses on, and he's well situated. He's ready for a nice evening. He's got a girlfriend. He's got a sports car. What more could he need? So these kinds of ads were banned as a result of the master settlement agreement. You won't see them anymore except if you bother looking them up on the internet. There were efforts over the years to restrict commercial speech related to tobacco. The most famous case is Lorillard Tobacco Company versus Riley from 2001. And I've given you on the Module 5 materials a link where you're actually going to be able to you could read the decision if you want, but more than that, what I wanted you to be able to do is listen a little bit to the argument of the lawyers for the tobacco companies and the government arguing before our United States Supreme Court. It's pretty interesting. It's about an hour long. You don't have to listen to it all, but dip in and out of it and just see how the dialogue goes. It's really a nerve-wracking thing for a lawyer to argue before the United States Supreme Court. Nine of highly intelligent people who are well versed in the issues and who are really grilling you, asking questions about the weaknesses in your case. And you have to try to convince them to come out your way. In this case, Massachusetts tried to prohibit outdoor ads, billboards of smokeless tobacco products and cigars within 1,000 feet of schools and playgrounds. And obviously, they were trying to address the impact of tobacco advertisements on children. They also said in their regulation that ads within places where these products were sold could not be any lower than 5 feet from the floor. And that self-service displays had to be out of the reach of children. The court applied that four-part test there, and they held that tests 1, 2, and 3 were satisfied. One, that the product, the product itself, although it was lawful, it was a product which could be harmful, and therefore it was within the rights of the state to regulate it. Number two, that the state had a legitimate interest in trying to regulate it. And three, that the regulation they passed was properly addressed to that concern. But four, they struck it down, saying that it wasn't really narrow enough to pass the constitutional test. It was a little bit too broad in certain of its aspects. So ultimately, the tobacco company won that case, but FDA, in the wake of that, has proposed regulations, but every time they do, the FDA regulations are challenged in court. And the appeals courts in the federal system have disagreed. The Sixth Circuit and the D.C. Circuit have come out completely differently on whether or not the FDA regs are constitutional or not. The regs would require very graphic warning labels, which actually show, lungs damaged as a result of smoking, or horrifying mouth and throat cancers that have resulted from smoking. The tobacco companies, of course, do not want to show these, and have challenged them in court. So in 2012, the Sixth Circuit held that FDA graphics were okay, because the current warnings were not getting across. There's still the use of these products out there in the marketplace. And the Supreme Court refused to hear an appeal from that. So that case, that decision stood. That goes against the tobacco companies. However, in R.J. Reynolds versus FDA, the D.C. Circuit Court of Appeals struck down the regulations, arguing that the third prong of the test fails because the government couldn't prove that the regulations would advance its substantial interest, and the FDA did not appeal. But the FDA is working on new regulations, which are out there now and are being considered. They were published in May, last month, and they're in the public comment phase. When the circuit courts decide differently on these FDA regulations, it causes a lot of confusion. So FDA will try to find a regulation that will pass the four-part test and yet be effective to address the concern. So take a look at this slide, and you'll see here that these are some of the warnings that the FDA rule will require. What you should take away from this is that the protection of commercial speech may discourage public health authorities from advancing certain restrictions, because it's very costly to litigate these things, and the results are often uncertain. But if the government can figure out how to make the restrictions effective, then they will be able to implement some regulations and enhance some of the labeling on harmful products.